Welcome to Perspectives, where we delve into complex societal issues. Today, we're navigating the incredibly sensitive question: should mental health issues be valid grounds for divorce or influence child custody decisions? This is a topic that touches many lives, balancing compassion with the practical realities of family law and personal well-being. Joining us to explore this are Dr. Evelyn Hayes, a clinical psychologist who will argue that severe, unmanaged mental health issues can indeed be valid grounds in certain circumstances, and Mr. Ben Carter, a family law attorney, who contends that a diagnosis alone should not be the primary factor, emphasizing support and the risk of discrimination. We aim for a respectful and insightful discussion. Thank you both for being here.
Thank you, Alex. It's a crucial conversation. My position is that severe and unmanaged mental health conditions can, and sometimes must, be considered legitimate grounds for divorce or significantly influence custody decisions. This is particularly true when these conditions lead to an unsafe, neglectful, or emotionally damaging environment for a spouse, or most critically, for children. We're not talking about transient sadness or manageable anxiety. I am referring to situations where a mental health issue profoundly impairs an individual's functioning, to the extent that the marital relationship becomes untenable or where it results in demonstrable harm. This could manifest as persistent emotional unavailability, chronic instability, neglect of fundamental responsibilities, or, in more extreme cases, abusive behaviors, whether emotional, financial, or, tragically, physical. The safety and well-being of family members must be paramount. While it is absolutely an illness and compassion is essential, the impact on the family unit cannot be ignored. When the condition remains unmanaged, when treatment is consistently refused, or when, despite all efforts, treatment proves ineffective in mitigating harmful behaviors or severe dysfunction. In such instances, the non-affected spouse or the children are living in a state of perpetual crisis or suffering. The very foundation of the marriage, mutual support, safety, shared responsibility, can be completely eroded. From a psychological perspective, prolonged exposure to such an environment can have devastating long-term consequences, especially for children's development and their own future mental health. The home should be a sanctuary, not a source of constant distress. Therefore, when a mental health condition, due to its severity and lack of management, effectively leads to what might be termed constructive desertion, or creates an atmosphere of intolerable cruelty, it is not only reasonable but responsible to consider it a significant factor in legal decisions regarding the family's future.
Thank you, Alex and Dr. Hayes. I appreciate the gravity of this discussion. My fundamental position is that a mental health diagnosis in and of itself should not be a primary ground for divorce, nor should it automatically dictate custody arrangements. Mental health conditions are illnesses, much like physical illnesses. We don't typically grant divorces solely because a spouse develops diabetes or heart disease, especially if they are managing their condition. The legal framework, particularly in no-fault divorce states, focuses on the irretrievable breakdown of the marriage. While behavior stemming from an unmanaged mental health issue might contribute to this breakdown, the diagnosis itself isn't the legal trigger. When it comes to custody, the guiding principle is unequivocally the, quote, best interests of the child. This standard requires a thorough assessment of actual parenting abilities, the capacity to provide a stable and safe environment, and the nature of the parent-child relationship. A parent with a well-managed mental health condition can be just as capable and loving as any other parent. To presume unfitness, based solely on a diagnosis, is discriminatory and fails to recognize the spectrum of mental illness and recovery. There's a significant risk of stigmatization if we allow diagnoses to be weaponized in family court. It could discourage individuals from seeking help for fear of legal repercussions, which is counterproductive to family well-being. Instead, the focus should be on demonstrable behavior and its impact. If a parent's conduct, regardless of its underlying cause, endangers a child or renders them incapable of providing adequate care, then the court has mechanisms to intervene. But this is based on actions, not labels. Our priority should be to encourage and facilitate access to treatment and robust support systems for the individual facing mental health challenges, and for the entire family unit. Divorce, or stripping parental rights, should be measures of last resort, not a default response to illness.
Dr. Hayes, Mr. Carter raises a crucial point about discrimination. How do you ensure that considering mental health in these decisions doesn't unfairly penalize those with manageable conditions, or those actively seeking treatment?
That's a vital distinction, Alex. My argument isn't about penalizing someone for having a diagnosis. It's about acknowledging the reality of severe, unmanaged, and impactful conditions, where the behavior stemming from the illness creates an untenable or harmful living situation. The key is the demonstrable impact on the family. Is the individual actively engaged in treatment? Is the condition stable? Are they capable of fulfilling their roles and responsibilities within the family, particularly as a parent? Professional assessments are critical here. A thorough psychological evaluation can help determine the severity of the condition, the extent of its impact on functioning, the individual's insight into their illness, their willingness to adhere to treatment, and the prognosis for improvement, especially concerning safety and stability for children. It's not about the label of depression or bipolar disorder. It's about whether the manifestation of that illness, despite reasonable attempts at management, consistently results in, for example, an inability to provide basic care, emotional abuse, or severe neglect.
Mr. Carter, Dr. Hayes speaks of situations where there's clear harm or risk due to untreated or unmanageable mental illness. How does the legal system protect children or a spouse in such scenarios if the illness itself isn't a direct ground for divorce or primary determinant in custody?
The legal system already has robust mechanisms to address harm and risk, irrespective of the underlying cause. If a spouse's behavior makes cohabitation unsafe or intolerable, that can constitute grounds for divorce under existing fault-based criteria in some jurisdictions, or contribute to irretrievable breakdown in no-fault states. Regarding children, family courts can issue protective orders. They can mandate supervised visitation if a parent's behavior poses a risk. Custody evaluations, conducted by neutral professionals, focus on parenting capacity, the ability to provide a safe environment, and the child's specific needs. These evaluations will certainly consider any behavior that impacts parenting, such as neglect, emotional instability, or endangerment, whether it stems from mental illness, substance abuse, or any other factor. The court addresses the symptoms and their impact on the child. So the tools are there to protect vulnerable parties by focusing on conduct and its consequences, rather than making the mental health diagnosis itself the legal battleground. The emphasis should always be on encouraging treatment and providing support first, and using legal interventions to manage risk when those efforts are insufficient or refused.
Let's consider a specific, challenging scenario. A parent suffers from severe, recurrent major depression, leading to prolonged periods where they are functionally incapacitated, unable to care for themselves, let alone their young child. They also show a pattern of resistance to consistently adhering to treatment plans. How should this be approached in a custody dispute, balancing compassion with the child's undeniable need for stable, predictable care?
This is a heartbreaking but not uncommon situation. The child's need for consistent, reliable, and nurturing care must be the primary consideration. Chronic unpredictability and parental incapacitation due to severe, treatment-resistant depression can be profoundly detrimental to a child's emotional and developmental well-being. While compassion for the suffering parent is essential, the court, informed by expert assessments, may need to establish a parenting plan that ensures the child's stability. This might involve awarding primary physical custody to the other parent, with structured, perhaps initially supervised, visitation for the affected parent. Conditions for increased parenting time could be tied to documented, consistent engagement in treatment and demonstrated stability. The goal isn't punitive. It's to create a safe and predictable environment for the child, while still encouraging the parent's recovery and involvement when they are capable.
This scenario indeed highlights the complexities. Legally, the focus remains on the parent's current ability to provide safe and adequate care, and the impact of their condition on the child. The diagnosis of severe depression is context, but the evidence must demonstrate the actual incapacity and the negative effects on the child. A comprehensive custody evaluation would be paramount. It would assess the severity and chronicity of the depressive episodes, the parent's insight, the reasons for treatment non-adherence, and the availability of a support network. All avenues for supporting the parent in their role should be explored. This could include therapeutic interventions for the parent, co-parenting counseling, or involving supportive family members. If, despite these efforts, the parent remains unable to provide consistent and safe care, then the court must act to protect the child's best interests, which might mean limiting that parent's custodial rights until there's sustained improvement. The emphasis is on the impact on the child, not just the diagnosis.
In closing, while empathy and support for those struggling with mental illness are absolutely vital, we cannot shy away from the difficult realities that sometimes arise within families. The well-being, safety, and healthy development of all individuals, particularly children, must remain our paramount concern. When severe mental health issues, despite all compassionate efforts and attempts at management, consistently create an untenable, harmful, or neglectful environment, it is not only justifiable, but necessary for these realities to be acknowledged as significant factors in legal decisions that shape the family's future structure and ensure protection for its most vulnerable members.
To conclude, the legal system must tread carefully, focusing on demonstrable conduct, parenting capacity, and the actual impact on the family, rather than on diagnostic labels alone. This approach helps to avoid discrimination and the potential for mental health conditions to be unfairly weaponized in emotionally charged legal disputes. Our societal and legal emphasis should always champion a supportive framework, vigorously encouraging and facilitating access to treatment and mental health resources. The goal is to preserve family units and protect individuals through healing and support, resorting to legal interventions that alter family structures only when absolutely necessary to safeguard well-being, based on evidence of impact, not just diagnosis.
Thank you both, Dr. Hayes and Mr. Carter, for your incredibly nuanced and thoughtful perspectives on this profoundly challenging issue. You've clearly illuminated the core tension, balancing the illness, individual rights, and the pressing needs for safety and stability within a family when mental health becomes a central concern. We hope this discussion encourages continued dialogue, empathy, and understanding on this important matter. Thank you for joining us on Perspective.